Without further ado, Mr. Blazer will be handling the opening statement on behalf of Invenergy.
Thank you. Mr. Blazer?
Thank you, Madam Chair, Director Coit. This is a somewhat unusual setting for someone who's spent his entire career as a litigator.
I cannot hear, I'm sorry.
Please remember to speak directly
Right.
to the microphones they're listening.
Does that work?
Yes.
Good. I've been struggling for some time to come up with what to say this morning in a procedural setting like this one. Routinely, when you talk about an opening statement, it's a presentation to the finders of fact of what the issues are and what you believe the evidence will be. But here, we know, at least in broad strokes, what the issues are. They're set forth in the 3 principal criteria in the Facility Siting Act. And as for the fact, we have all of this pre-filed testimony. So it would seem that what the issues are and what the evidence the parties expect to produce is really already before you. So that was a bit of a struggle for me. But when we were here a couple of weeks ago on the 11th, a couple of statements from the opponents to the project really crystallized for me what I'd like to talk to you about this morning. These are the 2 statements. The basis for the motion, as the EFSB knows, is that the only application pending before the EFSB is for a 2-turbine, 1,000-megawatt project. The only evidence that Invenergy has put in so far pertains to a 500-megawatt, 1-turbine project. The issue is that the evidence may not be matching the application. The application is for 2 turbines, 1,000 megawatts. There's no evidence in the record, and there won't be, on 2 turbines, 1,000 megawatts. Now that, frankly, might make an eye-catching news headline, but it's just not true. So this morning I want to talk to you about facts. Not the types of alternative facts that have become far too prevalent in our society today, but what we believe are the real facts in this proceeding. No rhetoric, no hyperbole, just the facts. Now, I'm not going to go through in painful detail this massive stack of pre-filed testimony from our 23 witnesses. We have several days over the next few months of hearings where you'll hear from that, about all of that in painful detail. So I'd like to focus instead on what we believe is not at issue in this proceeding. Some might argue that all of our witnesses are hired guns and you shouldn't believe any of them. And of course, dedicated professionals like these don't put their reputations on the line in pursuit of baseless claims. But I'll give the opposition their due. They may believe, either really or for strategic purposes, that our witnesses' veracity is potentially subject to question. And from that perspective, I suppose, the same can be said of the opposition witnesses. The town, for example, as we know, is adamantly opposed to this project. They issued a resolution to that effect, Town Exhibit 34. And so, in the same vein, we must consider the possibility that some of their witnesses, if not all, may exhibit a certain level of predisposition. With that said, I believe the vast majority of Burrillville's concerns relate to health and safety. Very understandable concerns. And I also believe that during the course of this proceeding, we will be able to allay those concerns. At least we will certainly try. And I must say, in the spirit of cooperation and candor, we appreciate the fact that the town and Invenergy now agree that there was no effort to pass hundreds of millions of dollars of costs down to the ratepayers, the letter that was submitted to this board just a few days ago. As for CLF, Of course, we know they are similarly opposing the project, and I suppose you can say the same concepts apply to them. But if we move away from hired guns and predisposition, you have an unusual benefit in this process that frankly is new to me. We certainly don't see in normal litigation, or frankly even in other permitting proceedings that I've been involved in around the country. You have these advisory opinions. Historic Preservation, Department of Health, Statewide Planning, Office of Energy Resources, Department of Environmental Management, Department of Transportation, and Public Utility Commission. No predisposition, no hired guns, no one with an agenda. Just state agencies doing what they are statutorily mandated to do, and in fact, more specifically, in your preliminary decision and order, what you asked them to do, to provide advisory opinions to assist you in this process. Now, the Energy Facility Siting Act provides that you can accept, reject, or modify these opinions. And I'll be perfectly candid and say to you that we don't agree 100% with every single thing in these advisory opinions. And we'll address those few instances, then they are very few, during the course of this hearing. But again, the most important thing is that these opinions are unquestionably unbiased. Again, I'm not going to go through all of these. Those will also be covered in painful detail over the next months. So I just want to focus on some of the highlights. And I think it's important, not just for those of us here, but in the audience, those watching remotely, to go through the elements that an applicant must prove to obtain a permit from this board. So here they are. Number one, construction of the proposed facility is necessary to meet the needs of the state and/or region for energy of the type to be produced by the proposed facility. Number two, the proposed facility is cost justified and can be expected to produce energy at the lowest reasonable cost to the consumer, consistent with the objective of ensuring that the construction and operation of the proposed facility will be accomplished in compliance with all of the requirements of the laws, rules, regulations, and ordinances under which, absent this chapter, a permit, license, variance, or assent would be required, or that consideration of the public health, safety, welfare, security, and need for the proposed facility justifies a waiver of some part of the requirements when compliance cannot be assured. A superb run-on sentence. And then number three, the proposed facility will not cause unacceptable harm to the environment and will enhance the socioeconomic fabric of the state. So I want to focus this morning specifically on three of the concepts that are addressed in those criteria: need, cost, and this concept of unacceptable harm. Let's talk about need and cost. As I said, these advisory opinions are in part the result of a statutory mandate. And focusing on the Public Utility Commission, subsection D of section 4298(9) of the Facility Siting Act. The Public Utilities Commission shall conduct an investigation in which the Division of Planning of the Department of Administration, the Governor's Office of Energy Assistance, and the Division of Public Utilities and Carriers shall participate and render an advisory opinion as to the need for the proposed facility. Now, we believe, based on what we've heard up until now, that the project opponents going forward will focus primarily on the argument that new renewable energy projects are adding electricity to the grid, while energy efficiency programs are reducing demand, and that therefore, this facility is not needed. So I'd like to go through some of the things that the Public Utility Commission had to say about that. This is from that advisory opinion. And I'll remind you that this opinion was the result of a full public hearing process. One of the unusual things from my perspective, you had a full public hearing process resulting in an opinion to assist you in this public hearing process. And the PUC found that both Clear River units are needed. A few highlights. Page 2. I am of the opinion that Clear River is needed in order to meet the electric generation reliability needs of southeastern New England and Rhode Island customers. Page 3. I am convinced that energy efficiency and renewable energy supply cannot, at this time, reliably meet the need for which Clear River will be built. The record revealed that, at least in the foreseeable future, generating units such as the proposed Clear River facility are needed in order to meet Rhode Island's clean energy goals. Page 5. Even if sufficient generation exists, replacement of inefficient old plants with clean, efficient new plants may have economic as well as environmental value. Absent a gap between supply and demand, new plants may still be considered needed by the region. In the end, it is the market that will supply the answers. Similarly, the Commission has stated that in the competitive generation market, new generating units are built as merchant plants, where the risk of selling electricity and the cost of plant construction are placed upon private investors rather than ratepayers. Based on the findings of prior commissions, I agree that the appropriate assessment of need in this matter occurs in the context of this changed risk dynamic, away from ratepayers and toward investors. Page 6. The award of a capacity supply obligation by ISO New England, the regional transmission operator for the New England region, is one component in the need analysis and is evidence of need in the wholesale market in the near term. Page 7. Capacity that clears the forward capacity auction is, by definition, needed. Therefore, because Clear River Unit 1 cleared the forward capacity auction 10 in accordance with the wholesale market rules and has a capacity supply obligation, Clear River Unit 1 is needed for system reliability commencing in June 2019. However, obtaining a capacity supply obligation is only one component of the need analysis. Page 8. While the existence of a capacity supply obligation signals a need in the short term, that should not be the only component reviewed in this matter. The PUC has a history of reviewing not just short-term need and reliability, but also longer-term needs of the region and of Rhode Island. Page 10. Based on the fact that ISO New England has identified as a challenge to reliability the approximately 10,000 megawatts of retirements and at-risk for closing of non-gas fossil fuel fired generation in New England, the entire Clear River facility is needed for continued reliability in the region. I want to highlight that again. The entire Clear River facility is needed. Page 20. Renewable energy resources, while undoubtedly representing the future of energy generation, do not, at this time, provide a cost-effective alternative to large, efficient gas-fired generators like Clear River. Rather, such generation is necessary to allow for the integration of renewables as they become more prevalent in the wholesale market. The Clear River facility will have the characteristics that will help Rhode Island continue to meet its environmental goals. Page 20. Wind power, while an increasing part of the portfolio, and I want to digress here for a moment, and this will come out in the hearing. Invenergy, the company that I am proud to represent, is the largest renewable energy development company in North America. When we talk about renewable energy, we are at the forefront. So, wind power, while an increasing part of the portfolio, remains a small portion of the regional capacity, and inadequate transmission is an obstacle to adding more at this time. According to ISO New England, most of the region's wind resources are located in northern New England. Many of the new wind power proposals are located where the transmission system is already constrained, particularly in Maine. To be able to deliver more wind power from existing resources, as well as to access more Canadian hydropower, significant additional investment will be required in electric transmission infrastructure. Delivering wind power for proposed projects to distant consumers will require major upgrades of the transmission system. Page 21. Solar installations are multiplying, but still make a relatively small contribution. I will add again, on behalf of Invenergy, we're also one of North America's leading developers of solar energy. Even less so on short winter days or when there is cloud or snow cover, and is not dispatchable when needed by the ISO New England. The addition of renewables has actually increased the need for flexible, fast-starting gas generators like Clear River due to the intermittent nature of renewables. Page 21. Not only will Clear River not impede the development of renewable resources in Rhode Island and our region, it will, to the contrary, aid and assist with the future development and integration of renewables. For this reason also, the Clear River facility is needed. Page 22, conclusion. Repeating. It is my opinion that Invenergy has met its burden of proof that the entire Clear River facility is needed in order to meet the electric generation reliability needs of southeastern New England and Rhode Island consumers. Now granted, that opinion was issued about 1.5 years ago. So one of the questions that we'll address during this hearing is, what's changed in that 1.5 years? Well, when that opinion was issued, Unit 1 had a capacity supply obligation, Unit 2 did not. Today, Unit 1 still has a capacity supply obligation, and Unit 2 still does not. What do we expect to hear from our opponents about that? Well, I believe it's the same thing we've heard up until now, and it's about this document. This is the September 29, 2017 qualification determination notification issued by ISO New England. And when we notified you about this letter last fall, our opponents described it as a bombshell. Is it really a bombshell? Is that a fact or just more hyperbole? Well, let's see. Two important things in this letter. Number one, this determination is only applicable for FCA number 12, the one that just happened in February, for the 2021-22 CCP beginning June 1, 2021. And number two, the ISO, in consultation with its consultant, has determined that commercial operation for the aforementioned project, focusing again on Unit 2, is unlikely to occur by the start of the 2021-22 CCP beginning June 1, 2021 because of delays in the permitting process and deferrals in the ordering of major equipment. Now, we all know those delays have nothing to do with this board. We all know the circumstances that led to those delays. But the important thing about this letter, the non-bombshell, is number one, it was limited to the forward capacity auction that just occurred, and number two, it has nothing to do with whether or not that unit is needed. It was exclusively because of delays in this process. So what's the bottom line about this? What do we believe the evidence will show? That each auction is a snapshot in time, securing existing resources for only a single 12-month period, 3 years before they're needed. That the system that ISO New England has set up will always ensure that there's enough capacity to meet the needs 3 years in the future, and as that demand forecast changes, they will adjust it. And finally, that you can't take one point in time and link it to a decision that was made in a completely different point in time. So in summary, I believe the evidence will show the following. Number one, that required capacity and therefore need is satisfied in the forward capacity auction by selecting new and existing capacity at the lowest possible price. Number two, that Unit 1, as the PUC indicated, is in the forward capacity auction and cleared, and by definition, it's needed. That there are still over 5,000 megawatts of at-risk units, as defined by ISO New England, that will retire. That the older at-risk units are retiring. That trend will continue because the remaining older at-risk units are, well, getting older. That they'll be subject to what are known as pay-for-performance penalties. And that even though demand may be down for now, ISO New England confirms that it will go up and new capacity will be needed. And finally, that new units that can offer in at a low price will be what the market is looking for, and that is exactly what Unit 2 will do. All right, I want to turn to another bit of hyperbole. 2 weeks ago, when we jointly agreed to make public portions of Glenn Walker's testimony, it was afterwards touted as another seismic event. Now, with all due respect to Mr. McElroy, since it's his witness, the evidence, I believe, will show that Mr. Walker's opinion is based on an improper metric. The PUC, as I indicated before in its advisory opinion, confirmed that Clear River will, quote, provide material savings to Rhode Island ratepayers. You will see that our expert, Ryan Hardy's analysis, and that's an analysis that was found to be reasonable by the PUC, demonstrates that Clear River is estimated to save Rhode Island electric ratepayers between $119 million and $365 million over the first 4 years of operation alone. Mr. Walker's contrary claim that we are in fact costing ratepayers appears to be based on the fact that we had to sell our capacity obligation for the 2019-2020 period. We had to sell it because we weren't operating yet. I'll say first of all that that process, what's called the reconfiguration auction, is in fact allowed by ISO New England's tariff. But more important, Mr. Walker's claims that the amount we made on this sale is costing the ratepayers money in high-capacity markets are just not true. Among other things, it ignores a number of facts, not the least of which is that Clear River's participation, before it's even generated one electron in the latest capacity auction, confirmed that we are already lowering energy costs for Rhode Island consumers and meeting a critical need while driving older, dirtier energy sources to retire. The evidence will show, I believe, that had that 485 megawatts of Unit 1 from Clear River not cleared the auction, the final clearing price could have been as much as 31% higher. By one estimate, that amounts to an energy savings for the entire New England region of $870 million. The evidence will also show that, assuming you grant our permit application, and we certainly hope you do, Clear River Unit 1 will begin operations in 2021 as planned, and that Unit 2 will begin operations in 2022 as planned, because there is still a demonstrated need for the affordable, reliable energy that from both units in the coming years. I want to talk for a moment about the opposition's position, or what it's been so far and what we believe it will continue to be. I want to digress a little bit. I hope you'll bear with me. There is a marvelous play and movie called Inherit the Wind. The premise is, the backdrop is the Scopes trial in Tennessee in the 1920s that addressed the issue of whether or not evolution could be taught in public schools. And there's one soliloquy in particular that I think is really apt under these circumstances. It's the Clarence Darrow character in the movie played by Spencer Tracy, and in the movie his name is Henry Drummond, and he's talking to the judge. And he says the following: "Can't you understand that if you take a law like evolution and you make it a crime to teach it in public schools, tomorrow you can make it a crime to teach it in the private schools. And tomorrow you may make it a crime to read about it. And soon you may ban books and newspapers. And then you may turn Catholic against Protestant, and Protestant against Protestant, and try to foist your own religion upon the mind of man. If you can do one, you can do the other. Because fanaticism and ignorance is forever busy and needs feeding. And soon, Your Honor, with banners flying and with drums beating, we'll be marching backward. Backward. Through the glorious ages of that 16th century when bigots burned the man who dared bring enlightenment and intelligence to the human mind." Now, I can't do Spencer Tracy justice, nor am I suggesting that CLF wants anything as severe as burning us at the stake. At least I don't think so. But you have to wonder, in the context of the energy situation in New England, when groups like CLF oppose gas, oppose wind, oppose solar, oppose hydro, what are we left with? Marching backwards to burning whale oil? All right. Let's turn to what I think we can all agree is the most important issue to be addressed during these hearings: health, safety, and that concept of unacceptable harm. As far as I can tell, there are two principal opposition arguments: that the project will disturb the integrity of western Rhode Island's forested habitats and wildlife corridors, and that the project would undermine Rhode Island's ability to achieve greenhouse gas reduction goals. I want to focus here on DEM, the Department of Environmental Management. It has a very basic, fundamental mission: protection of human health and the environment. Something in my career as an environmental lawyer that I'm quite familiar with. So here's the issue again. The proposed facility will not cause unacceptable harm to the environment and will enhance the socioeconomic fabric of the state. What harm is unacceptable? Or conversely, what harm is acceptable? There's a famous line that's been butchered a bit by Supreme Court Justice Potter Stewart that was in the context of a First Amendment case. And in addressing the issue before the court in that case, he said, "I can't describe it, but I'll know it when I see it." Fortunately, in this context, we don't have to deal with a definition that's quite so nebulous. When we talk about acceptable or unacceptable harm, we're really talking about a process of balancing. So I want to focus principally on the issue of public health. But first, particularly seeing what I think will be behind the cover on that board up there, I'd like to address the location of the proposed facility. This is from the September 2016 DEM advisory opinion. And it's kind of a penultimate statement with respect to this section of that opinion. Page 9. The proposed project is located in a large, intact, forested area of high conservation value. And this, unfortunately, is one of those limited portions of the advisory opinions that we don't agree with. And frankly, it's not just us. I will say this, though. If we look at the supplemental advisory opinion from DEM from August of last year, page 15, DEM strongly urges the EFSB to consider the foundation of the wetlands regulatory construct when evaluating this area, that such impacts must be avoided and minimized to the maximum extent practicable through specific conditions and requirements if the facility is ultimately approved. Now, our witnesses will fully address these and other related concerns and confirm that, as DEM recommends, we have avoided and minimized impacts to the maximum extent practicable. And note, please, that maximum intent extent practicable does not mean complete elimination. But for now, I want to focus on one critical fact that seems to have been lost in all of the rhetoric about the location of this project. The statewide planning advisory opinion. We'll start with the one from September of 16. First of all, before we even get there, a few conclusions from that opinion that are consistent with the PUC's opinion. Page 8. The program finds that the project will have a positive impact on the state's businesses. Page 13. The program finds that the construction and operation of the project will result in positive revenue benefits to the state. Page 14. The program finds that construction and operation of the Clear River Energy Center will have a positive impact on the town of Burrillville's municipal revenue. Page 14 again. The program finds that the project will enhance energy reliability, resulting in positive benefits to the surrounding region. But here's the most important part in the context of the concerns expressed by DEM regarding the proposed location. It's page 38 to 39. The program finds that the project, 1, would be appropriately located, 2, would not detract from land use 2025's vision of maintaining a rural-urban distinction excuse me, within the state's communities, and 3, would further portions of Land Use 2025 Goal 4. First, class supporting infrastructure that protects the public's health, safety, and welfare, fosters economic well-being, preserves and enhances environmental quality, and reinforces the distinction between urban and rural areas. The program believes that the project is appropriately located, consistent with Land Use 2025 Objective LUO 4D. Locate new infrastructure in appropriate areas, and is not inconsistent with Land Use 2025 Objective LUO 1A. Focus growth within the urban services boundary and in centers of different sizes and types. Support traditional centers instead of new development. As reported by, I'm still quoting, as reported by Edward Pimentel of Pimentel Consulting, and you'll hear more from Mr. Pimentel during this proceeding, of course. Although Clear River will own in excess of 67 acres, less than 1/2, or approximately 29.44 acres, will be dedicated to the operation proper. The operation will be aligned along the rear westerly portion of the property, thereby maintaining in excess of 37.6 acres in a naturally vegetated state. The site will have a naturally vegetated frontage, which will provide screening from the residents situated along Wallem Lake Road. In addition to the site being vegetatively screened, its use for electrical generation would not be likely to promote the residential or commercial sprawl that Land Use 2025 seeks to minimize. The program finds that the project furthers Land Use 2025 Goal 4, first-class supporting infrastructure that protects the public's health, safety, and welfare, fosters economic well-being, preserves and enhances environmental quality, and reinforces the distinction between urban and rural areas. The primary feature of the project is the construction of the Clear River Energy Center, a new, high-efficiency electric generation facility. This new supporting infrastructure will serve the public's health, safety, and welfare by helping to meet its demand for energy. And these points are even more concretely stated in statewide planning's supplemental advisory opinion from last August. Page 16. Green Space and Greenways for Rhode Island's Future recommends the development of a mapped system of specific protected open spaces, green space resource areas, green belts, primary and secondary natural corridors, and bikeway and trail corridors. Here's the finding. Development of the project site is not in conflict with a greener path because the location is not identified as a mapped component of the state's green space and greenways plan. The project site is a 67-acre subset of a 730-acre property that is privately owned by Spectra Energy. It is immediately adjacent to the Algonquin gas compressor station and natural gas pipeline, which has been developed for industrial energy-related purposes for at least 3 decades prior to the adoption of this state guide plan element. The project site is close to, but outside of, the green space network envisioned in a greener path, leading to the finding that the project is not inconsistent with this state guide plan element. Starting at page 20. Ocean State Outdoors is the state of Rhode Island's comprehensive plan for outdoor recreation, conservation, and open space. It builds off of a greener path by envisioning a statewide system of connected green spaces and greenways. A network made up of critical natural and cultural resources, outdoor recreation facilities, public spaces, community and urban forests, and public and private open spaces. As noted in our assessment of a greener path, the project is not located in an existing or proposed green space or greenway area. Additionally, the site is privately owned and would not require the conversion of any existing protected land. While the project site is located in a general area of high conservation value and important recreational resources, the development of the subject property would not hinder the state from expanding the statewide network of green spaces and greenways elsewhere. The 2005 Rhode Island Forest Resources Management Plan establishes a vision, goals, and policies, and provides recommendations focused on the management of tree resources within the state of Rhode Island. This plan does not, however, establish policies for the outright prohibition of the development of forested lands. Private landowners have the right to utilize and develop their forested lands until such time that direct conservation acquisitions are made or formal land management regulations are enacted through appropriate public channels at the state or local level. And here's an example of the balancing that I talked about, still on the same set of pages. Although the area is relatively undeveloped, the project is adjacent to existing energy infrastructure systems, namely the Spectra Algonquin natural gas pipeline and compressor station and National Grid's electrical transmission lines. One of the primary tenets of the state guide plan, found in several sections throughout, is that development should occur in close proximity to the underlying infrastructure that is needed to support it. In this instance, close proximity of the primary fuel source that is needed to produce the electrical energy and the transmission network that is needed to distribute it is particularly relevant. And then most recently, in their second supplemental opinion just this past February, this was addressing the implications of the temporary disqualification of Unit 2 from FCA 12. Page 10, socioeconomic impact conclusion. While the delay in the construction and operation of the Clear River Energy Center does change certain economic variables, it does not affect the program's original conclusion that the project will have an overall positive socioeconomic impact for the state of Rhode Island. I want to focus on one particular point that statewide planning mentioned 3 separate times. And that's the fact that the property on which we propose to develop this project is private property. And I'll repeat one quote again from that original opinion. The site will have a naturally vegetated frontage which will provide screening from the residences situated along Wallem Lake Road. As statewide planning pointed out, the entire property that's privately owned, including that vegetated frontage, is 730 acres, of which we'll be taking 67. In theory, and actually not in theory, really in fact, the owner, Spectra Algonquin, could clear-cut that entire acreage and develop anything they choose, so long as it's consistent with applicable land use regulations. So there is in reality only one thing that will serve to minimize the impact of development on this property, or at least our portion of it. And that's the fact that Invenergy is developing a power plant and will implement numerous mitigation and conservation measures as part of this process. But for that, members of the board, this property would be subject to far greater impact than what the opponents have so far pointed to. All right, now let's turn to public health. And on this subject, more than any other, we really have to be very careful to separate fact from fear-mongering. So, I'll start first with a line that jumped off the page at me from the 2016 Department of Health Advisory Opinion. It's page 34. It is not possible to create a no-risk environment. There's that balancing again. So let's focus on what the evidence will show that we are going to be doing. First, some general conclusions that I think are appropriate. I'm switching from DOH to DEM, that I believe are critically important. Page 27. Compliance with the carbon dioxide emission standard for a baseload unit can be expected. Page 28. Compliance with the carbon dioxide emission standard for a non-baseload unit can be expected. Finally, compliance with the carbon dioxide emission standard for a multi-fuel fired unit can be expected. Still on page 28. As it appears that the operation of the facility will displace other fossil fuel fired generation resources, it is DEM's opinion that the proposed facility will not affect compliance with the Regional Greenhouse Gas Initiative annual emission cap. Additionally, as the Federal Clean Power Plan is not applicable to the facility, compliance with the Federal Clean Power Plan is not affected. I'll talk a bit later about that reference to the Clean Power Plan. Page 29. Whether the facility will present an unacceptable harm to the environment. DEM is charged with determining whether projects and activities present an acceptable harm, and there's that balancing again, to the environment through the various permits, licenses, and reviews authorized under the Rhode Island general laws and the associated rules and regulations promulgated thereunder. Projects and activities determined to be compliant with the thresholds and standards set for acceptability in those various rules and regulations in the context of harm to the environment are approved, often through the issuance of permits. Page 30. The judgment as to whether the facility as a whole will present an unacceptable harm to the environment will depend on the analysis and decision on each and every permit application required under these laws and regulations. Now the supplemental DEM opinion, page 14. If DEM finds that the applicant has complied with the requirements of the applicable regulations, a permit will be issued for that proposed activity. The issuance of a permit indicates that DEM has determined that the nature and scope of the proposed activities are within standards for acceptable environmental impact established by state and federal laws and regulations. Page 14. If upon completion of the regulatory processes, the requisite environmental permits are issued, it is a formal declaration that the proposed facility has met the standards and criteria for acceptable harm to the environment as established in state and federal laws and regulations. Let's turn to the Department of Health. Obviously, weighed in on the same issues, focused primarily on air pollution and asthma. This is the 2016 advisory opinion, page 17. Invenergy has applied to RITEM for I was told yesterday that I shouldn't call it RITEM, but DOH did. It makes it appear that I'm not from Rhode Island. I should call it DEM. Invenergy has applied to RITEM for a major source air pollution control permit for the facility. To obtain that permit, Invenergy must demonstrate that the facility will comply with the requirements of 18 of RITEM's air pollution control regulations, including APCR number 9, air pollution control permits, and APCR number 22, air toxics. Note the APCR number 22 lists health-based acceptable ambient levels, AALs, for approximately 250 air toxics. Among the requirements for obtaining a major source permit, APCR number 9 specifies that permit applications must demonstrate that the facility emissions will be consistent with the lowest achievable emissions rate, known as LAIR, and that ambient air impacts from the facility will not cause a violation of any National Ambient Air Quality Standard, known as NAAQS, or AAL. To demonstrate compliance with NAAQS, an applicant must demonstrate that total ambient air levels, including the impacts from the proposed facility, background ambient air pollution concentrations, and impacts from nearby interacting sources, would not exceed the NAAQS levels. Compliance with NAAQS and AALs is evaluated using US EPA-endorsed air pollution dispersion models, which utilize several years of hour-by-hour meteorological data to determine impacts under a range of meteorological conditions. In addition, major source applications must include a health risk assessment, which evaluates potential impacts by all exposure routes. So, before going farther, I'd like to point out what we have already put into the record of this proceeding regarding Clear River's environmental impacts. Invenergy application, Section 6, Assessment of Environmental Impacts. Appendix B, Major Source Permit Application. Appendix D, Wetlands. Appendix E, Noise Assessment Report. Appendix H, Phase 1 Archaeological Survey. Our responses to DEM's first, second, third, and fourth set of data requests. Our responses to the town and EFSB data requests regarding Clear River's environmental impacts. Our wetlands addendum filed in 2016. Our on-site wastewater treatment system permit application. Our application to alter freshwater wetlands. Our air permit application. Our major source permit application addendum. Our multi-source modeling addendum. Health risk assessment. Water supply plan. Supplement to the water supply plan. Biological inventory report, and responses to DEM's comments filed with the board on January 22 and April 12 of this year. Now, the Office of Energy Resources also weighed in on these issues. This is from their 2016 opinion. And first, this board had directed OER, in collaboration with the Executive Climate Change Coordinating Council and with assistance from DEM, to render an advisory opinion as to two issues: the impacts of the facility on anticipated greenhouse gas emissions that would result from the proposed facility, and the cumulative impact over the life of the project. And number two, whether the facility will conform to the requirements and provisions of the Resilient Rhode Island Act. Now, going back to where I started with this, just want to refocus on one thing. OER's opinion was based on the fact that the facility will be configured as a 2-unit, one-on-one, duct-fired combined cycle generating station. So, page 16 of that opinion. Clear River's natural gas units have an estimated net plant heat rate of 6,254 BTU per kilowatt hour, which would make it one of the most efficient combined cycle plants in the region. Its low heat rate, combined with the competitive cost of natural gas over the forecast period, make it reasonable to expect that Clear River will be dispatched early in merit order and therefore displace less efficient dispatchable generating resources with higher unit costs of production, primarily resources that burn coal or oil as a fuel source, as well as less efficient gas-fired resources, all of which have a higher CO2 emission rate on a pound per megawatt hour basis. Page 17. Because energy from less efficient, higher emitting sources across the state and region are displaced, there is a net decrease in overall CO2 emissions. Page 19. Energy generated from Clear River will displace generation from the higher emitting marginal unit each hour that Clear River operates, thereby lowering the system average emission rate. Page 20. Over the long term, The region's generation fleet will evolve to reflect further retirements of aging fossil fuel plants. Continued expansion of carbon-free resources such as wind, onshore and offshore, subject to opposition, and solar generation, and state and federal policies that will increase the cost of emitting carbon. All of these likely future events will contribute to the further decarbonization of the bulk power system. Continued operation of Clear River will foster this objective, or at least not impede progress. Page 20. Clear River and other more efficient gas-fired plants will continue to put downward pressure on energy prices, narrowing the gap between the price paid to a generator and the cost of the fuel and other variable costs to produce electricity. This gap is commonly known as the spark spread and is directly related to the profitability of a power plant. Narrowing the spark spread puts increased economic burden on the remaining oil and coal-fired plants in the region. Page 21. As renewable penetration increases over the long term to meet the region's aggressive RPS, RES, CES goals, we expect that generation from all gas-fired resources, including Clear River, will diminish and emit less CO2. Importantly, economic risks due to the diminished operation of Clear River as it competes with renewable generation and more efficient, cleaner plants in the future are not borne by customers in Rhode Island, but solely by the project owner. Page 27. Since Clear River reduces the overall regional consumption of all types of fossil fuels used for generation, it is reasonable to conclude that the project does not increase upstream methane emissions and may actually contribute to reducing upstream impacts. Page 30. Regarding the Resilient Rhode Island Act, the construction of Clear River will not impact existing statutory mandates designed to diversify and decarbonize Rhode Island's electric supply portfolio. Construction of Clear River will not impede Rhode Island from tackling emission reduction potential in other carbon-intense areas of the economy, transportation, and thermal. Page 30. OER concludes that Clear River will not impede Rhode Island's ongoing commitment to clean energy investment through policies and programs that include, but are not limited to, least cost procurement, the Renewable Energy Standard, the Renewable Energy Growth Program, net metering, and participation in multi-state clean energy procurement initiatives as authorized by the Affordable Clean Energy Security Act, such as the multi-state clean energy RFP between Rhode Island, Massachusetts, and Connecticut. These policies will continue to help Rhode Island achieve its fuel diversity and greenhouse gas reduction targets by supporting the continued penetration of clean energy resources in the state's energy supply portfolio. The construction of Clear River does not alter or hinder in any way the statutory and policy provisions underlying these key initiatives. Page 32. According to ISO New England, adding more wind and solar powered resources in New England will paradoxically increase the region's need for more fast response, flexible resources, which in many cases will be natural gas-fired generators. Until grid-scale energy storage technologies become economic and widespread, the region will be calling on natural gas resources to counter fluctuations in output from renewables. And I only have to say 2 words to remind everybody what we recently went through here, bomb cyclone. Page 34, ultimate findings. The facility will contribute to reducing CO2 emissions associated with electricity used in Rhode Island, which is derived from generating resources across New England, as well as imports from neighboring regions. In the long term, over the life of the project, Clear River will not cause CO2 emissions across the region to increase, although its contribution to reducing regional emissions is likely to diminish. Second, development and operation of the project is consistent with state energy policies and will not hinder Rhode Island from meeting its GHG reduction targets under the Resilient Rhode Island Act. And third, development and operation of the project will not be detrimental to implementing Rhode Island's policies and statutory initiatives to increase energy efficiency and the expansion of renewable sources of electricity. We're not done. Supplemental advisory opinion, February 26, 2018, in the aftermath again of the temporary disqualification of Unit 2. Page 11. As discussed in OER's September 2016 advisory opinion, Clear River is anticipated to be one of the most efficient gas-fired resources in the region, and therefore generation from Clear River will displace generation from less efficient and higher emitting fossil-fired resources, excuse me. Page 14. Clear River would be one of the most efficient generators in the region, displacing generation from higher emitting fossil fuel generators without hindering the expansion of clean energy resources. With the increase in renewable generation and decrease in coal and oil-fired generation, the carbon intensity of the region's electric generation fleet has decreased in the updated cases relative to the application. Therefore, in the updated cases, generation from Clear River displaces relatively less coal and oil-fired generation and instead displaces more inefficient gas-fired generation, which mutes the avoided emissions benefit of Clear River, increasing the penetration of renewable resources and eliminating energy generation in the model therefore diminishes, but does not eliminate, the claimed CO2 emissions benefit of the project. Page 18. OER concludes that operation of Clear River will contribute to a reduction in the region's deep greenhouse gas emissions from the energy sector. Page 19. Three conclusions again. Despite a potential delay in commercial operation date, the facility will contribute to reducing CO2 emissions associated with electricity used in Rhode Island, which is derived from generating resources across New England, as well as imports from neighboring regions. However, Clear River's contribution to reducing regional emissions is likely to diminish over time. Second, development and operation of the project will not hinder Rhode Island from meeting its greenhouse gas reduction targets under the Resilient Rhode Island Act. Third, development and operation of the project will not hinder the implementation of Rhode Island's clean energy policies, programs, and statutory initiatives. Now let's go back to the issue of public health. Consistent with the DEM and DOH opinions, we believe the evidence will show that for this type of project, to which the requirements of the Prevention of Significant Deterioration, known as PSD, program apply, applicants like Invenergy are required to perform an air quality impact analysis that demonstrates that the predicted project air quality impacts, when combined with the air quality impacts from other nearby emission sources, will not cause air pollution in violation of any NAAQS standards or DEM acceptable ambient level. Now, there are two types of NAAQS for the criteria pollutants, and those are sulfur dioxide, particulate matter, nitrogen oxides, carbon monoxide, ozone, and lead. The first standard, and I really want to highlight this one because it's often missed in proceedings like this. This is the primary NAAQS standard, designed to protect human health, taking into consideration sensitive populations, including children, the elderly, and individuals with respiratory ailments. And second, secondary standards designed to protect public welfare, including effects on soils, water, crops, vegetation, man-made materials, animals, wildlife, weather, visibility, property, and climate, as well as effects on economic values and on personal comfort and well-being. These are the conditions that have to be met for the issuance that we have to meet for the issuance of a major source permit for this project. We must apply the lowest achievable emission rate, again, LAIR, and offset its nitrogen oxides and volatile organic compound emissions by a greater reduction in the actual emissions of those pollutants from other sources, because Rhode Island is in what is known as the ozone transport region, You suffer the effects of coal plants that operate in places as far away as Pennsylvania and Ohio. We must demonstrate through an analysis of alternatives that the benefits of the project outweigh the environmental and social cost imposed as a result of its construction. We must demonstrate that its emissions will not cause an impact on the ground level ambient concentrations at or beyond the property line in excess of any acceptable ambient level. We must conduct any studies required by the guidelines for assessing health risks from proposed air pollution sources and meet the criteria in those guidelines. We must demonstrate that the facility will be in compliance with all applicable state or federal air pollution control rules or regulations at the time it commences operation. We must apply best available control technology for each pollutant the facility would have the potential to emit. We must demonstrate that the allowable emissions from the facility would not cause or contribute to air pollution in violation of any NAAQS or any increase in ambient concentrations exceeding the available PSD increments. We must provide an analysis of the impairment to visibility, soils, and vegetation that would occur as a result of the project and any associated general commercial, residential, industrial, and other growth. We must provide an analysis of the air quality impact projected for the area as a result of any associated general commercial, residential, industrial, or other growth. The major source permit that we hope to obtain from DEM for this project will include short-term and annual emissions limits for each emissions unit and facility-wide. The permit will also include specified monitoring, record-keeping, and reporting requirements to ensure that compliance with all applicable regulatory requirements is maintained at all times while the facility is in operation. The facility will be equipped with continuous emissions monitoring systems, CEMS, to continuously monitor and report compliance with its emissions limitations. The facility will be required to maintain specified records and submit compliance reports to DEM and the EPA on a monthly, quarterly, and annual basis. Finally, the permit will require Clear River to notify DEM in writing whenever a permit condition has or will be exceeded, with corrective action required by DEM in as timely a manner as possible. I said previously that I'd come back to the mention of the Clean Power Plan in DEM's advisory opinion. It seems today almost like ancient history when we talk about the Clean Power Plan. And as we all unfortunately know, there is an ongoing effort at the federal level to, quote-unquote, relax environmental standards. Most recently, the administration directed US EPA to ensure, and this is a quote, efficient and cost-effective implementation of the National Ambient Air Quality Standards Program by reducing burdens for states that want to create their own compliance plans, instead of being forced to use a federal plan and consider international emissions when calculating a state's compliance with a particular standard, among other things. And that is a very euphemistic statement for what we all know to be an alternative agenda. Here's another quote from the DOH advisory opinion, page 17. RITEM's regulations provide a comprehensive framework for evaluating impacts of air pollution emissions. Rhode Island's air toxics regulation is one of the most stringent in the nation, and the requirement for a health risk assessment for major sources provides an extra level of protection. I want to be very clear about this. We do not consider the temporary results of catering to a dying coal industry to be an appropriate method for assessing the requirements applicable to a facility like this one. We therefore, I wrote here, we therefore expect. That's not a good enough word. We will insist on a condition that this facility will need to meet the standards in effect today, not some nebulous and temporary relaxed standards that equally temporary holders of the reins of government might implement. So getting back to the purpose of an opening statement. to apprise you of the issues and what I believe the evidence will be. We will try to strip away the misleading rhetoric, the exaggeration, and the media-tailored sound bites, and just focus on the facts. You have a very difficult job here. And it's not because the issues and the facts before you, particularly given your experience, are particularly that complex. In the context of our experience, they're not. And particularly not in the context of the evidence that's already before you. No, I think this process will unfortunately be made unnecessarily difficult by efforts to confuse, to distort, and to deny plain facts. To toss around alternative facts. That's what we heard 2 weeks ago, and that's what we can all expect to continue to hear. And so what can you expect from us? Well, just focus on the facts. And what are the facts here? That this is the single largest privately funded infrastructure project in the history of Rhode Island. That it is needed. That it will not burden ratepayers. That it will be safe. And that it will help Rhode Island and all of New England meet their energy needs for decades to come. Thank you.